happens if you go to trial on a domestic violence case and lose? In this video, I'm going to be explaining exactly that. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to win your domestic violence restraining order hearing. So if that is something that you're dealing with in addition to dealing with criminal charges, you can get your free first class via the link down below. Okay, so let's jump right in. What happens if you go to trial on a domestic violence case and lose? Even if you're thinking, you know what, the potential for trial, that trial's a long way off, I'm not thinking about trial right now, you should be. Because even early in your case, when you are trying to figure out how to evaluate, for example, an offer that the DA gives you, or how seriously to take the case before court, very seriously, by the way, many times it can get dropped before court, you need to know, what is the worst case scenario? If I were to fight this to the end, what's worst case scenario if I lose? Okay, so first of all, it depends on what the charges are. Penal Code 273.5A is the most common domestic violence arrest in the state of California. Typically, when you're arrested for this, it's going to be a felony arrest. So your bail will be set at $50,000. All your paperwork says felony. If they file charges, and this is something that potentially you can have an attorney help you with before court, potentially get them to drop charges or get them reduced. But when the prosecution actually charges it, it could be filed either as a felony or as a misdemeanor. There's also PC 243E1. That is a misdemeanor charge for domestic battery. The difference between those two charges, by the way, which I won't get too much into, but is basically that 273.5 is supposed to be when there's a physical injury. It's called a corporal injury to a spouse, or for PC 243E1, it can be just pushing the other person, but there is no injury, for example. All right, so if you go to trial for a felony PC 273.5A charge, and I'm going to assume for the purposes of this video that this is your first time being arrested for domestic violence, and there is no GBI allegation. GBI is an enhancement that can be added to a case, like an extra charge, where they say that there was a really bad injury. Typically, it's where there's a broken bone or stitches or something really severe. So I'm assuming that that does not exist, and it's just PC 273.5A. It's your first arrest. You don't have any strikes or anything like that on your record. If you go to trial and lose on a PC 273.5A charge, is the judge will make a decision as to what your sentence will be. If the prosecution charged you with a felony, and so this whole time, as this case has been going on, a felony has been hanging over your head, the judge can still reduce it at the time of sentencing to a misdemeanor. So you heard that right. Even though it was a felony this whole time, even though the prosecutor wanted it to be a felony, the judge can decide based on what they've heard at trial, based on good things about you called mitigation that your attorney presents, they can decide to reduce it to a misdemeanor. Now, if the judge does not reduce it to a misdemeanor, then you can be sentenced for up to 4 years in state prison. But the judge does not have to give you prison time. You may see, if you're looking this up, that it says 2, 3, or 4 years in state prison. Well, that's a pretty big difference. And you also may be wondering, okay, is 2 years then the minimum? No. The judge can sentence you to probation instead. And in fact, to sentence you to 4 years, to sentence you to the max in state prison, there have to be specific findings of factors in aggravation. Things that make this case and what you have been found guilty of doing here especially bad. For someone who doesn't have any criminal history, this was the first time, it's unlikely that that would happen. Very unlikely. In fact, if it's your first time, and your attorney does a good job of presenting all of the good things about you, all of that mitigation, and anything else, any hardships that you've gone through. Perhaps you started going to domestic violence classes or individual therapy. There are links for those down below, by the way, if you're not enrolled in them yet, in the description box. You enrolled in those early on, and your attorney presents that to the judge. You have a good shot at getting probation and having this be something that eventually can be expunged from your record. Now, let's say that either the prosecution charged you with a misdemeanor originally, That can be PC 273.5A or the PC 243E1, so they charged you with a misdemeanor. It will be the same process where your attorney gets a chance to present good things about you and hardships you've experienced. The prosecution gets to present negative things about you or about your conduct, and then the judge still has to make a decision to sentence you. Now, the worst case scenario, and this, again, I'm assuming that you don't have any strike priors, this is your first time arrested, there are no additional charges here. This is all that we're talking about here. One charge of one misdemeanor. The worst that can happen then is that the judge can sentence you to a year in jail. Now, a year in jail, again, that's the max. That is throwing the book at you. Either the allegations here are really bad, which, I mean, if it's charged as a misdemeanor, they probably aren't. The judge really hates you for some reason. Maybe you acted really inappropriately during trial. Maybe the judge just doesn't like the look of you. You know, you never know. The judge has discretion here, and that's important to remember. Or because you've had a bunch of priors, you've been arrested for domestic violence before. Maybe last time they dismissed the charges before court, or you got classes in exchange for a dismissal, and now you're back, and now you're taking it to trial. And even if you get sentenced to a year in jail, at least here in Los Angeles County, typically they're keeping people for around 10% of their time. And the most that they can keep you for in the state of California, as long as you get good time and work time credit, is half the time. So again, you have a good shot if this is your first offense ever, and there are a lot of good things about you for your attorney to say. Maybe you've been going to the classes and the therapy that I always talk about because it is so important. It makes a big difference. You have a good shot at getting probation, and again, getting something that can be expunged from your record. When you are evaluating an offer from the prosecution, and you will get an offer in almost every case, when you are deciding what to do, you have to know what you're deciding between. So on the one hand, here's the offer. On the other hand, here's going to trial, and what is a worst case scenario if you go to trial? And what's the realistic worst case scenario? You need to understand those two things. So if you are offered, for example, on a misdemeanor PC 273.5A, 52 weeks of domestic violence classes, and you know that if you get this conviction, you will lose your job, for example. And you're thinking, okay, but I don't know if I want to go to trial. I know the alleged victim's going to show up there and testify against me, and I don't feel that good about going to trial. Well, if you know that worst case, if you go to trial, like absolute worst case, is that you would get pretty much the same thing that you've already been offered, but with more jail. But on the other hand, you might win the trial, right? You might win and not have a conviction at all. Maybe the alleged victim doesn't show up. Maybe the alleged victim shows up and your attorney tears her to shreds with her inconsistent statements, right? You have at least a shot there. And of course, every case is different. Maybe you set it for trial and the DA is busy and the DA's supervisor says, get rid of this case. You can't spend 2 weeks on trial. We need you. We have so many other things for you to do. And at the last minute, they say, you know what? Okay, you want classes in exchange for a dismissal? You want credit for all those classes you've already done? Fine, we'll give it to you. If you don't set it for trial and you just take the deal, you get rid of that possibility. And you know that if you do take that plea, if you know that it's going to cost you your job and it's going to ensure that you do have to go to jail for sure for some period of time, and you do have to be on probation and still have this on your record and not be able to expunge it for some period of time, maybe the idea of going to trial is not actually that bad. I hope that this video has given you a better understanding of how to make those decisions throughout the case. How to know if you should accept a plea bargain or not. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on TikTok, Instagram, and Facebook.